So what change did you make in 2020 for your business or organization that contributed most to your ability to adapt and thrive, as well as your name and your organization in the chat? Okay, good. And then let's see. As always, we are here as supporters of entrepreneurship and entrepreneurs in particular. And our goal is to increase the ecosystem's ability and capacity to help entrepreneurs be more successful faster. That's the single most important thing that connects every single one of us here, is making entrepreneurs more successful faster. And I'm going to turn it over now so that we can have a lot of time with our legal friends from Ogletree Deakins. It's our labor law deep dive with Ogletree Deakins, and they have all of their slides, and they will do all of the introductions. And once again, and I will post in the chat the question as well. So welcome to everyone, and Michael, I'm going to turn it over to you.
Thank you, Erin, and good to see everybody this morning. I'm going to try to share my screen right now. Give me 1 second here. Can everybody see that, the introduction slide?
Yep.
Yes.
We see it.
Great. Well, we have certainly been honored to be the sponsor of the workshop again this year. It's certainly been an interesting year to be the sponsor, and we've had to navigate a lot of different legal issues related to the pandemic. We talked about the FFCRA when that was passed back in February, March timeframe. We talked about the CARES Act, and we talked about a lot of other issues related to the pandemic. And then as we approached this workshop, we took a step back and looked at different legal issues that could affect small businesses and the entrepreneurs that you support. And we're going to dive into some of those topics more in depth today. Just like we did last December, I have two other attorneys with me here today, Ann Cauble and Brooks Miller. They're both associates in the Greenville office as well. And once we get to their portions, I'm going to let them introduce themselves and tell you about what they're going to be presenting on today. But today's meeting will look a little bit different. For about the first 15 minutes or so, each of us will give a broad overview of our topic. I will start, and then I'll probably hand it off to Brooks, and then we'll conclude with Ann. And then at that point, the attendees will get a chance to select which breakout session they would like to go into. So you can choose my session, Brooks's session, or Ann's session, and talk more in depth about these topics and have more of an open discussion on these particular topics. So be listening for what we're sharing and what you think might apply to either your business or an entrepreneur that you are currently supporting. And then after that is done, we will reconvene in the general session for about 5 to 10 minutes, where myself, Brooks, and Ann will then share some of the highlights of our breakout session. So it's going to look a little bit different today. And we have Jared Burgess from our IT department that's helping us out. So I'm hoping that he can help navigate these breakout sessions, because I am not very technologically sound. So we're going to give it a shot today. But what I'm going to be talking about today is independent contractor versus employees. We're going to talk more in depth about this topic. It's a topic that we've touched on generally over the last couple of sessions, but I think it's such an important topic to understand and be able to spot issues for with small businesses. And if you choose my breakout session, I'm not advocating for that, but I will give you some examples of clients recently that have run into some issues with independent contractor versus employee classification, just to give you some practical examples of how some of this might play out. So I'm going to talk very briefly right now about some of the differences. Obviously, independent contractors don't have rights to many employment benefits like employees would have. They're not going to be subject to workers' compensation coverage, unemployment if they were to get terminated. And probably the most prevalent issue when you're looking at this classification, independent contractor versus employee, is the wage and hour issues, the withholding under the IRS. But the wage and hour issues under FLSA and the South Carolina Wage Payment Act that Brooks is going to talk about, that's really where you're going to see these issues, not paying individuals the proper wages if they're really an employee, but you think they're an independent contractor. And so how do we distinguish whether an individual is an independent contractor versus an employee? Well, South Carolina's common law test has 4 factors. You'll see here the right to control, who furnishes the equipment or materials to complete the job, the method of payment, whether you're paying an individual weekly, bi-weekly, or by job, for example, and also the right to fire. Now, these are factors. They're not elements. Not all of them have to be met, but they have to be weighed together. And based on the facts and circumstances of that relationship, we must determine whether someone is truly an employee or an independent contractor. There's also a DOL test that's used for the FLSA and wage and hour issues at a federal level, a new proposed rule that also focuses on control. There's a number of different factors, more so than the South Carolina common law test, but again, it's going to come down to control primarily with the DOL rule. And also the IRS has a test as well, which has a number of different factors, 15 to 20. We're not going to look at those in depth, but again, that also comes down to control. And one of the most important things to keep in mind is that it's in order to make this determination, it's not what the business wants the relationship to be necessarily. It's how the relationship is actually playing out in practice. And this is where we run into problems. Businesses might hire someone or think they are hiring someone as an independent contractor, but what they are really doing is bringing on an employee. And then they're not paying them properly. They're not withholding taxes properly. And so it's going to come down to how that relationship is actually playing out based on the facts and circumstances versus what you believe the classification actually is. And that brings me to my next point about the agreements. I've been asked the question, if I have an independent contractor agreement with an individual, is that, the end all be all, and are they an independent contractor? Well, it helps, but it's not necessarily the case, again, because even if you have that agreement in place, if in practice you are controlling the means and methods of their work, if you are paying them like an employee, if the entire relationship looks and smells like an employee-employer relationship, then that's what is going to control. So those are a few of the things that we're going to look at if you join my session in the breakout. And we'll also talk about some of the other laws that could be affected with this analysis, the independent contractor versus employee analysis. So with that, I'm going to pass it off to Brooks here to talk a little bit about his topic and also to introduce himself.
Thank you, Michael. Yes, my name is Brooks Miller. I'm also an attorney with Ogletree, and once I figure out how to share my screen, we're going to talk about onboarding. I think that's showing up right. Does everybody see that? Okay. So what is onboarding, and why is it important? It's really, it's that first impression. Like when you meet somebody, you only get one chance of making first impression. That's what onboarding is for a company and a new employee. It's helping them adjust to the company from a work standpoint, a social standpoint, and the performance aspects. It's important because, you know, the studies out there show that, you know, individuals on average change their careers 5 to 7 times. And so this is critical because when you're bringing somebody in, you're not bringing them in hoping they're going to change their job 5 or 7 times after you've hired them. You want them to be a, you know, successful employee for you. So this is where you really start from day one to get that employee engaged and be a part of the company, and certainly not regret joining the company. You want to use this as a time to connect with a new hire and avoid overwhelming them. I've got death by orientation there, and this can be from an orientation where you just inundate somebody and you say, here's a stack of documents, sign these, watch these 10 hours of training videos and get to work. Or it could be no onboarding process at all, where they just show up and they're kind of just left there floating to do whatever. It's so either one of those are going to have a negative impact, and so it's important to take a detailed and efficient approach to your onboarding plan, because if you do that poorly, that's, you know, that's your first impression, and somebody's going to be walking in day one saying, what did I just sign up for? Why am I here, kind of thing, and not going to be inclined to maybe stay with the company and be looking to change their career again. So that's why, you know, from a global standpoint, it is very important to have a detailed plan for this. Again, as we were just discussing, why is it important? You know, you lay the groundwork from day one, kind of explain to somebody what their role is and their jobs and what's expected. So it's going to boost productivity if you have a clear plan from the outset. It's going to help retain those employees. It's going to build your culture. And it's certainly just make it clear what the company expects from the employers and from the employee, and vice versa. We kind of look at this in the 4 C's of onboarding, a way to kind of structure a general outline of a plan. You know, the first of those would be compliance. This is going to be the stuff that is going to be the really important day one things. It's going to be your basic legal policy and company procedures, things like signing their, you know, their I-9s, which Anna will talk about, any kind of handbook policies and things like that. The really important day one things. And then clarification. The second C is going to be when you have the employee show up, you want them to understand kind of what is expected from the employer's point of view in terms of what their jobs are going to be, what type of assignments you're going to be giving them. And this is one of those things that you talk about on day one, but it's not done on day one. You introduce it on day one, say, look, here's the job, here's what we expect, but this is something you check in on the second week, the third week, the fourth week. That's why onboarding is not a 1 week process, a 1 day process. It's more of a 1 year process, really. So you can kind of make sure they understand how the job's going, and so they're not getting lost and wasting the company's time and resources. The third C is culture. Again, this is sort of not only teaching a new employee about the company itself, it's going beyond really a company's histories, but really teaching them about the company's values and things that I think, you know, I focus on. This is things you typically overlook, like company lingo. How do people talk in the office? What are the communication styles, meeting styles, all those things you take for granted if you've been for somewhere for several years, that a new person coming in is not going to know the lingo or what to expect in meetings or how meetings are run, those kind of things. It's important to integrate new employees on that and make sure they feel comfortable with the culture of the company. And then the fourth C is the connection. Again, this is really driving home, making somebody feel comfortable on the job. You know, this is where you're going to really see high retention and limiting turnover, really making somebody feel comfortable. A pretty easy way to do this, building that connection, is early on establish like a mentor for somebody or an open door policy, letting them know they can come ask a certain person any kind of question they have, so they're not feeling lost on the job from day one. And that's going to make them feel more comfortable and hit the ground running. Some practical considerations, and we can talk more about this in the breakout, but again, that's, you know, you don't want to avoid dumping large quantities of information on new employees all at once. Again, kind of rolling this out over time. There's certain things you got to do day one and week one, but it's not everything. There's going to be trainings that can extend over the first month, you know, the first several months, the first year. Keep track of everything you're doing along the way. Of course, you want to check the boxes that, you know, first day they showed up, they signed necessary work. We've got W-4s, we've got our handbook policies signed, things like that. But also keeping track of things you want to do down the road so you don't lose track of that. And this will help you, you know, build a efficient onboarding program for the future. It's an evolving process. You'll be able to learn what went well, what didn't go well. So it's always important to document what you've done and learn from that. I've got a sample onboarding plan for just kind of the structure here. Again, we can talk about more of the details in the breakout, but it's what we've been talking about so far. You know, the first step is preparing for the arrival. That's your day one task, your critical documents they've got to sign. You know, your first few days, again, assigning a mentor, building a structure around the person to feel comfortable to learn about the job, their expectations, their initial work assignments, and what the type of work they'll be doing down the road. The first few weeks, again, checking in, you know, again, don't let somebody just join the company and that's it. And you got to keep tabs on them, make sure they're understanding what they're doing, provide feedback. So if something's not going right early on, that's corrected, and you know, it's not wasting company resources or time, and the employee feels comfortable. The first few months, same thing, focusing on any additional feedback, training, making sure that they're comfortable with who their mentor may be, or their support group, or the team they're working with. And then the first year is kind of a time to reflect, see what went well. I think it's important to really talk with new employees after they've been there for, you know, the first 6 months, first year, to see how did that process work for them when they joined the company. That's a good chance to learn, because every time we come up with a plan, of course, we think it's the greatest plan ever. In reality, you may learn some things work better than others, and it's important to understand that feedback so you can improve it for the future to continue to have happy employees and retain the employees. So that's kind of a quick overview. I've listed a few resources here that will help have kind of examples of onboarding plans and things like that, and we'll discuss more in the breakout. In the breakout, I'm also going to talk about some other things that affect the onboarding process, like the offer letter, the handbook disclaimer, and the Wage Payment Act. So we can do that in the breakout and answer any questions about those topics, and I have a few more slides on those. But with that, I believe I will turn it over to Ann now.
All right, can everyone see? Great. So I'm Ann Cauble. I am with Ogletree as well. I practice immigration law. So I do both sides of immigration law. I do compliance, which is mainly, you know, I-9 compliance, or, you know, kind of paperwork compliance from an immigration perspective. And then also visa work. So, you know, H-1Bs, Ls, all different types of visas, the whole alphabet soup of visas. So today we're going to be talking about you know, I-9s, and that's what my breakout session is going to be. You know, I talked about this last year. It never ceases to amaze me how interested people are in talking about I-9s, considering it's, you know, a 2-page form. But there are always questions. So we're going to go over the I-9 basics. You know, most importantly, when it comes to I-9s, is making sure that you do them right the first time. So yes, it is a 2-page form. It gets lumped in with all that other onboarding paperwork. It's kind of shuffled at the back, and you're trying to rush and get it done so that you can get this person started. But it's important to get it done right. And then also, you know, audit the I-9s, make sure you fix any that are wrong. And actually, you know, you should really be auditing, kind of checking over the I-9 as it's being completed. So we'll go into detail on that. And we'll also go over some guidance for I-9s during the pandemic. So there was a little bit of hesitation on the part of Immigration and Customs Enforcement and Department of Homeland Security when it came to I-9s. Particularly inspecting original documents, since that is a requirement for the I-9. They have, you know, granted a little bit of flexibility with the inspection of original documents because of the pandemic. So we'll go over that process. And even though there's flexibility now, what you need to do in the future when your employees return to work. So that's kind of just a quick overview. And, if you join my breakout, we'll go into more depth on that.
So I think what we'll do now is we will have the breakout sessions, and we will plan to reconvene at about 11:40, and then at that point we can all discuss some of the big hitters, so to speak, or main points that we learned from the breakout session.
And one of the things about the breakouts is you will be able to choose which one you want to go into. Jared is handling that for us, so I expect that you will see on your screen a choice of 3 at some time.
Right. And Michael, Ann, and Brooks, I've enabled you all to record in each of your rooms. So once you get to your room, when you look at the bottom, you'll have an option to start your recording. That will allow us to capture each room. I'll open the rooms now.
Does anybody know how long this should take?
I was going to say, are we supposed to see something pop up where we choose?
I'm interested to see how this is going to work, because I believe that he's going to have to do a poll and then manually interpret that in order to put us in the right room. But he might know some cool technology I'm not aware of yet.
Well, there's supposed to be something, because we were supposed to have used it when we did our event a few weeks ago, and we had 100+ people, and it didn't work then either. So
If you're not seeing anything pop up on the screen, if you hover the mouse around the bottom, you should see some options, and one of those is hopefully breakout rooms.
Okay, I do not see anything of that type.
I don't see that either.
I cannot find anything either.
Yes.
Oh, technology.
Well, this is a cool feature. I'm looking forward to seeing it.
No pressure, Jared.
Oh, wait.
Right.
Okay, so please join our breakout rooms.
Yeah,
What
I
is
have
that?
a message. Where do you go?
Oh,
At the very top, there's a little
Yep,
blue
I
button.
see it.
got it. I click it, but nothing happens.
Right.
If it doesn't work, what we could do that we've done before is just have everybody change their name and add a 1, 2, or a 3. So, if they want to do 1, it would be Michael's, and then 2 would be Brooks, and then the third one as well. So we could do it that way.
Well, why don't we give him one more moment to see if he can figure it out, and then I guess we'll. He can tell us if you want to go that route or hang on for.
Yeah,
Jared,
I'm not
you
seeing any other option to force anything to you other than this message.
See, I'm looking in participants.
Yeah. I mean,
No,
we're getting the
okay.
message, but it doesn't give you the option to.
Well, since there's so few of us, would we like to all just stay in the same room?
Yeah, let's just do that.
And we can ask
Yeah, that will be
questions?
good.
Good.
Yeah, I
Katrina,
selected the
nice to see
option
you
to
as well.
stay in the same room. Did it work?
All right, so I'm going to go ahead and start, and I'll be brief, and we can go from there. But one thing I will say is, it is a smaller group, smaller room, so please jump in, ask questions, give examples if you have any recent examples, really with any of these topics, because I think that's what's going to help the group moving forward. But let me go ahead and just share my screen again. And everybody's.
Michael, if you don't mind me jumping in, and everyone, if you would, please feel free to unmute yourself and ask a question. We are a nice sized group to be able to do that.
The only question that I have, my name is Claudia. The only question I have is with the I-9s. For how long you have to keep those?
Anne, you're muted.
I see it now. I don't even think that I added that into my slideshow, but for
Sorry.
I-9 retention, you have to have an I-9 on file for every current employee. So anyone
Yes.
that's currently employed, you have an I-9. So that's the
Okay,
first
so
step.
if they are not working with me, I don't have to keep them on file?
You do for a certain period of time, but sometimes people interpret the retention requirements for terminated employees to apply to current employees. So I always like to start with, you have to have an I-9 for all current employees.
Yes, I understand that. And the other ones, for how long I have to keep?
So you have to keep them for 1 year from the date of termination or 3 years from the start date, whichever is later. So there's actually, hold on, let me pull up this. I'm just gonna use Google and share my screen because there's a really handy tool. It's like a little chart from USCIS.
Okay.
And what I normally recommend is actually just writing this this information like on a Post-it note.
Okay.
To the I-9. Whenever someone is terminated or they leave, whatever happens, pull out their I-9, stick on a sticky note, and include this information, and then that way you'll have it. And as you go through and like purge, whether you do that on a monthly basis or maybe a quarterly basis, you can really quickly look at the dates and know which ones you're going to purge. Before you ever destroy an I-9 though, double check that have someone double check your work, have someone double check your math, and make sure that, it really can be, purged. Can everyone see that? This is that little chart that I'm talking about.
Nice. Okay.
Okay. And I'm gonna send the link in the chat box as well, just so that you have it. But the USCIS website has great
They could have done a better job of that. They could have just had you enter the date and then figured out for you. That they didn't certainly use technology here.
Well, the I-9s, because a lot of them are still paper, even though a lot of people are moving to electronic I-9 systems, you don't really necessarily have the option to do it electronically. The electronic I-9 systems, a lot of them will actually track this information for you, which is helpful. But if
no, I meant the form. In other words, that form.
Oh,
there,
yeah.
In other words, that was designed to be a paper form. They could have just made it very easy and say, when did you hire the person and when did you terminate them? And then it would give you the answer.
That would be easier. That would be too easy. But that little kind of form is helpful. Just keep it handy, stick it on that sticky note on the I-9, and then you are good. And just have someone check your work before. If you're like me, you're not good at math, so you need someone checking your work before you purge any of your I-9s.
Sure. Thank you. Thanks for the link.
Yeah, no problem.
Since we're already on this topic, why don't you just continue and finish your portion? And I have a question too. You said it's a two-page form. Why is it important for small businesses, and what kind of issues can you run into if you don't fill it out properly?
Yeah, so with I-9s, there is actually, an enforcement mechanism for I-9s. So ICE, Immigration and Customs Enforcement, can come in and audit your I-9s, and if they find errors, which they will, you can be fined for those errors. And the rate of the fine, or the amount of the fine, depends on the rate of errors over your entire I-9 population. And then also, the different types of errors. So we can see fines that are just a couple $1,000s, but they can quickly add up. If you have small errors on multiple I-9s, then that just adds up. So for example, completing the I-9 late is a fine that's over $1,000. Let's say you have 10 employees and all of their I-9s are late. You could be looking at I-9 fines of over $10,000 just because paperwork wasn't completed timely. So it's really important to get the I-9s, as part of your onboarding process. We recommend actually, now you have to do it post offer and acceptance of the offer. You can't use it as a pre-screening tool, but you want to send it out and hopefully have people bring their documentation with them the first day of work. Make sure that that section 1 of the I-9 is completed. And then you do have 3 business days for section 2, which we'll get into, but just, we find that if companies make it a priority to do the I-9 the first day of employment, that really helps just ensure that they're done timely. So let's just dive right in. This is what the I-9 form looks like. So section 1 is for the employee to complete, and they have to complete this on the first day of employment. So first day of work for pay. Absolutely have to complete this. Now they can complete it before the first day of work, but you don't get the same 3-day rule. No later than the first day of work for pay. This is section 2. This is completed by the employer. You have 3 business days to inspect the documents and complete section 2 of the I-9. This box up here always gets missed. This is where you write in the employee's name. So just make sure you're doing that, so that if you lose page 2 of the 2-page form, that you can put them both back together and have a full record for that employee. And also right here, this language, if you read through it, it's a little blurry, but it says, I attest under penalty of perjury that you have examined the documents presented and that they appear to be genuine and relate to the employee name, The key word is under penalty of perjury. So this is a serious thing. Yes, it looks like a very basic form, but this is how they can catch you if you get into trouble. You're not doing what you're supposed to on the I-9s. There is the potential for criminal liability, and it's because of that phrase, under penalty of perjury. So we always want to make sure that we're doing them timely, doing them correct, but also pay attention. It is a pretty serious form, even though it seems very basic. This is the list of acceptable documents for the I-9. So the employee has to present list A or list B and C to show that they're authorized to work in the US. And some of these documents you would be surprised are on here. So for example, right here, driver's license issued by a Canadian government authority. Why in the world would a Canadian driver's license help show that you're authorized to work in the US? Well, they allow it. So if they present that and they have some other valid list C document, that's fine. But anytime you're presented with a little bit of a strange document or something that you haven't seen before, you don't automatically reject it. You always want to check and see if it's on the list of acceptable documents, and also check the M274 handbook that's listed down here. Sometimes they have additional guidance on documents that might not be as common. So as far as timing, and we touched on this a little bit, so the section 1 employee information must be completed by the employee on the first day of employment. It can be completed before, as long as there's been an offer and acceptance of that offer, but it cannot be completed, or if it's completed after the first day of work for pay, it's late. Section 2, verification of documents, and that section 2 must be completed by the 3rd day of employment. One thing that comes up pretty frequently is where employees don't have a document because it's either lost or it's been destroyed. And so they have the receipt for the replacement document. You can accept a receipt in certain situations, basically as long as the document was lost or destroyed. If someone is just getting, you know, work authorization for the first time and they've applied for it, but they don't have the card, that's not a situation where their card is lost or destroyed. That person is not authorized to work yet until they actually have the card in hand. So that's just an example of the receipt. So section 1, you know, obviously the employee is completing this, but when the employer gets to section 2, you want to look through section 1. You want to make sure that the employee, you know, checked the appropriate or checked a box, didn't check more than one box, that they filled it out completely, and that they signed and dated it. Make sure that they dated it also with an actual date. A lot of people date it with their birthday just out of habit. So, you know, make sure that that all is filled out and filled out correctly. If it's not, just print out a new section 1 and have them make the corrections if it's going to be super messy. You know, problem areas, we kind of went through that. One thing that you do want to look for, if they mark that they are an alien authorized to work until a specific date, you'll want to, you know, set a calendar reminder to make sure that you are re-verifying that person timely to ensure that they continue to be authorized to work in the US. Also, on the new form, or the, you know, the current form, there is a box that you're supposed to check whether a preparer or translator was used. So just make sure that that box is checked one way or the other. And really, you should only be using a preparer or translator if the person, the employee, truly cannot read or write and complete the I-9 by themselves, or, you know, they do not speak English, and so you need a translator. It shouldn't be just so that your I-9s are neat. So section 2, make sure that, you know, as the employer, you are reviewing the identity and work eligibility documents. Make sure you complete all the fields in section 2, mark as NA anything that's not, you know, applicable. And keep in mind when you're looking at the documents, you aren't supposed to be a document expert. You don't sit here looking at fraudulent documents frequently like I do. So if it looks valid on its face, you know, seems to relate to the employee, you know, you should accept it. You don't need to go into too much depth. You know, just make sure that it looks like it's a valid document, it's on the list of acceptable documents, and move on from there. And this says examine an original document. That is generally true, but you'll see as we get to the advice about the pandemic that there's been some flexibility with that. So the 3 questions you want to ask yourself when it comes to the documents: does it appear to be genuine? Does it relate to the employee that gave it to me? And does it appear to be tampered with or doctored? And really, that's it. If you can answer all of those questions or these 2 questions as yes and this one as no, you should accept that document. We talked about a little bit about that, just, you know, looking through the M274 and looking at the acceptable documents list to just become familiar with that. You know, make sure that the document matches the employee, that the picture looks the same, generally the same. Obviously, people age, gain weight, lose weight, but it should generally look like that person. And just make sure that the information matches up with what they listed in section 1. If their driver's license says their name is John Smith and they put that their name was Brad Pitt, that doesn't match up. So there's a problem. Okay. You know, as far as tampered with or doctored, you're looking for obvious issues. And one way that we can often tell that a document is fraudulent is actually misspellings. You're not usually going to get as lucky as having something quite as blatant as this, but misspellings, you know, on the front or back of a document can show that it's fraudulent. So just read through the document and don't be overzealous. So, you know, don't break out the blackout light to check to see the hologram on the driver's license is valid. You know, you're held to the norm or reasonable person standard, so you're not expected to be that expert, and you don't need to go to that length to check a document's validity. Okay. In section 3 of the I-9, this doesn't really apply to onboarding, but this is where you would have to re-verify employees whose work authorization is expiring. So this isn't for identity documents, so things like driver's license. Also, you do not re-verify permanent residents generally. If they provide a permanent resident card, it's also called an I-551 card. So no re-verification for them. And generally, re-verification must take place by the date of expiration. You can do it before if the employee volunteers it, but they do have up until the day that the document expires. So COVID has completely transformed the way that we work, and a lot of companies have gone remote. In response to this, the Department of Homeland Security did announce flexibility as it relates to inspecting the original physical documents provided for the I-9. So anyone or any employers who are having people work remotely can take advantage of this flexibility policy. You can basically review the documents via a video chat, something like this, or by email or fax to avoid having that in-person contact. And you have to, the same rules still apply as far as timing. You still have to review them within the 3 business days. But the important piece of this is you still have to review the original documents when you return to work in person. So when the remote policy ends, you were supposed to review the original documents in person. You don't just get kind of off the hook and have the option to review remotely and not ever go back and look at those original documents. So that's one piece that is really important. You need to make sure that once you return to normal operations, that you have that on your to-do list for anyone hired during, the remote work period where you were inspecting documents remotely. This policy right now is only extended until the end of the month, but it's been extended regularly, throughout the year since it went into effect. I expect it's going to continue to be extended, particularly under the new administration. I think that they'll be a little bit more flexible than what we've seen under this administration as far as, things related to COVID. So I do expect that will continue. But just make sure that as soon as y'all return to work that you are planning to review those original documents in person. One other piece of, oh yeah.
Aaron, we go till 12, correct? Okay. So,
okay.
So let's try to, if I could start in about 2 minutes, all I need is 5 minutes,
yeah.
and I'll hand it off to Brooks. I'm sorry to interrupt. I just want to make sure
we're
on time here.
You're good. Yeah, I'm almost done. So the only other flexibility, there have been some cases where the DMVs have shut down and people can't extend or get new driver's licenses. And so there's been flexibility with that as well. So you'll just want to, look at that. If someone's providing an expired driver's license and the DMV is shut down, then you can accept that as a receipt. So, and then if you're working remotely, one other option is to have someone like a notary complete the I-9 and review those documents on the employer's behalf. There are risks with that. Obviously, you're designated someone that's not part of your organization to review those documents in person. So you don't know that if they're going to do it correctly or, if you trust them to review the documents adequately. But that is an option if you just can't review the documents remotely. And that's it.
Cool, thank you. I'm going to try to share my screen again. All right. Everybody see that? Okay, I'm going to be very brief. I'm going to try to wrap up mine with a few very key practical points. We talked about what the courts look at, what these different agencies look at as far as the tests are concerned with determining whether someone is an employee or independent contractor. I'll tell you that if it's a close call most of these laws are going to generally favor the employer-employee relationship. So if it's a close call, that presumption or favor, so to speak, is going to be given in favor of that employment relationship. One of the reasons that this distinction is so important is for counting the number of employees. You'll see here, South Carolina Payment of Wages Act, which Brooks is going to touch on in just a few minutes. South Carolina Workers' Compensation, 4 or more employees. Some that you do not see here are the ADA, Americans with Disabilities Act, 15 or more employees. Title VII, the same, and Age Discrimination and Employment Act, the same, all 15. So as these businesses continue to grow, those are important laws to keep in mind with counting the number of employees. But let me give you a recent example of this as it relates to workers' compensation. Got a random call in to our office about workers' comp, and I'm known as kind of the workers' compensation guru, at least in the Greenville office. So I took the call, and it was a small landscaper here in South Carolina who told me that he had 3 employees and 1 independent contractor. He did not have workers' compensation insurance. That independent contractor got injured when he was performing landscaping work for a client. So I started asking him a lot of questions. I said, okay, well, you call this individual an independent contractor, so let's see here. When do you pay him? I pay him weekly. I pay him the same amount every week. I said, okay, who provides the equipment? He said, I do. I said, you know, who is telling him how to perform the work? Is he just going out and doing it himself completely on his own and you don't know what he's doing? Or are you telling him what to do, giving him the processes by which to complete the work? And it was the latter. So everything that I asked him pointed to the employment relationship. And he was in a sticky situation because he didn't have South Carolina workers' compensation insurance, which he should have, since that individual should have been an employee counting for the 4 or more, and that individual got injured. So you potentially didn't have the protections of that workers' comp system and could potentially be sued in tort, which you do not want to be in civil court if you can avoid it, if at all. So that's one practical example of how that misclassification can come out and really come into play. And also, if he was supposed to have workers' compensation insurance and didn't, and it's mandatory under South Carolina law, if you have 4 or more employees, then you can get fined for not having the insurance. So that's one thing that's really important, is that a lot of these laws that should be applying to the business or to the employee, you know, you're not thinking about that if you're saying that everybody's an independent contractor. And it's an easy trap to fall into with a small business. And I can tell you from firsthand experience, because my wife actually started a small business this year. And you aren't thinking about these legal issues. You're not thinking about onboarding, I-9s, or some of these issues that Brooks will talk about. But it's very important to attack up front and at least be able to issue spot so that you don't run into issues down the road. So speaking of the South Carolina Wage Payment Act that you'll see here applies to 5 or more employees, I'm going to turn it over to Brooks, and that's one of the things that he's going to talk about. But I believe he's also going to talk about the importance of having a handbook disclaimer or putting a disclaimer in offer letters if you're going to use that when you bring on an employee as well.
Great, and I'm going to interrupt 1 second. Michael, thank you for that. We have a question from Dean, and I hope I will ask it correctly. But he was asking about the new California law and whether or not it will have an impact on how people are categorized. He says he knows it's just for California, but that it might go national. Do you have any insight on that?
I read a little bit about that the other day, and you know, they have proposed a revised test to determine whether someone's an employee or independent contractor. From all accounts, it's very similar to the proposed DOL rule. which will make it easier for the employee-employer relationship to exist. So from a practical standpoint, and it still comes down to control, that's one of the main factors, even though they've shifted a lot of the other factors. So as a practical matter, I'm not sure if it will have a huge effect on the analysis, but I'd have to look into it more, to be honest with you. We try to avoid looking at California stuff here in Greenville because it's like looking at a different country's laws. But that's my understanding of it.
Okay. All right. Well, thank you very much. Dean, speak up if you have another question with that. But I have
No, I agree. California is definitely a foreign country.
Yeah. And I have one other quick question, Michael. Quite often, early stage companies will contract salespeople. And that, I guess all the same guidelines still apply. Can't tell them what to do, when to do, or how to do it. You pay them on, I guess, commission. But what about when it comes?
Yeah, in the sales world, it comes up a lot. It's very common to treat those individuals as independent contractors. I'd be careful, but I think you just go through that same analysis. And some salespeople might be considered employees, some might be an independent contractor. It really just comes down to that same analysis. But again, if it's a close call and you're looking at all these factors and saying, I don't know, it's not clear that they're not an independent contractor, you might want to think long and hard, because again, the law favors that employee-employment relationship.
Okay. All right, good. Thank you very much. Sorry, Brooks. Thank you.
No problem. Yeah, just had a few other quick things. Related to onboarding, I wanted to touch on a few other issues like the offer letter, kind of legal considerations that go along with that. Offer letter is obviously very important. You're going to want to stick to your specifics in there. So pointing out the pay structure, the benefits, the position offered, setting forth the conditions of employment. Typically what you'll see here is just saying, employment's contingent upon successful completion of things like the I-9 form, background checks, signing any other type of confidentiality agreements, etc. One of the most important things, though, is to stress that the employment is at will. Most of the time, when you're hiring somebody, it is going to be an at-will employee. So you want to avoid any language in the offer letter that would create any type of contractual obligations. So you don't want to say talking about definite periods of time or making promises for future earnings or bonuses, something that could be construed as creating an employment contract, be something beyond at will. So generally, it looks something along the lines of what's at the bottom of the screen there. This is a generic version, but you would say something like, glad to have you, look forward to you working here, but please note that the company is an at-will employer, which means your employment with the company is at will, meaning you can be terminated at any time with or without notice or cause. Nothing in this letter, our policies, our handbooks is going to change that relationship in the future unless we tell you otherwise. So it's important to have that type of language in an offer letter to avoid creating an employment contract. Similar to that, if you were hiring somebody who happen to have a non-compete with another company, that's something you'd want to know before they, one, join the company, and two, if they do, you'd want to have a separate agreement along with the offer letter saying, I understand I'm on a non-compete. I won't use any information from the prior employer. I've returned everything. I've complied with all my obligations there. So that gets into another area to really be mindful, to know if you're hiring somebody who does have a non-compete, to know the parameters of that and to make sure they're not in violation of it prior to hiring them, and that they agree to abide by it during the terms of the non-compete. The other key thing is a handbook disclaimer. Now, this is a South Carolina specific law. As you see it there on the screen, it's section 41.1.110. And what this says is, if you have a handbook or a policy or manual, it does not create an employed contract of employment if it is conspicuously disclaimed. And it tells you in the law what conspicuously disclaimed is. It means this disclaimer has to be in underlying capital letters on the first page of your handbook and signed by the employee. If it doesn't meet that, so if you had capital letters, but it wasn't on the first page, or if you didn't have an underline, or if it wasn't signed by the employee, if it doesn't meet all those things, then you don't get the benefit of this law. So as silly as that may sound, you have to meet all these requirements to get that protection. And it's very important to have that, because then you're starting at the presumption that the employee's employment is at will, and it's tough for them to get around it if they were to bring a lawsuit and say, no, they hired me for a certain amount of period of time and I was terminated before that, so they're entitled to damages from that. So it's really important to have, and I've got an example of one here. I know that may be a little small, but as you can see, this is in capital letters, it's underlined, it's in boldface too, just to be safe. This would be on the first page of a handbook. It goes through very clearly saying, you know, here's the handbook. It's not going to address every situation, but your employment is at will. Nothing in this handbook or anything you receive changes that employment at will, and it has a place for the employee to sign that. So this would be on the first page of the handbook, and it's very important to have them to sign that to get that protection of the law that the employment is at will. So again, I've seen cases a lot of times where they have this on, you know, the last page of the handbook. It wouldn't counter the law. I see it where it's not underlined or it's not capitalized. And again, as trivial as that may sound, if it doesn't meet all of the requirements, then it's all for naught, because you don't get the benefits of it. That doesn't mean you can't show that their employment is at will, but you got to jump through more hoops to do it instead of getting the protection of that presumption under that law we just looked at. And sorry, I'm speeding through because I know it's 12. And then the Payment of Wages Act, that is just another law that requires at the time somebody's hired, you have to notify them of their hours, the wages agreed upon, time and place of payment, and any deductions made from the wages. If at any point this is changed, you've got to give that employee at least 7 days notice, but it does not apply to wage increases. It's important to comply with this because each failure to pay would be a separate offense. So for every employee, it could, and missed payment period, that could be a separate offense, which you can face a civil fine for that, as well as a lawsuit from an employee to recover any unpaid wages. So sorry, I just breezed through a lot there, but that's right on noon, and I'm sure we can take questions for a minute or two since we're up against it, but just wanted to get that all in there. So thank you for listening.
I had a quick question. Could you point us to what maybe a sample culture statement, or tell us quickly about the importance of that and what not to put in it, or what should be in it?
Yeah, I mean, with the culture statement, I think that's you're kind of free to really talk about what the company atmosphere and things like that are. But again, the things I would say just don't put in there is any kind of statement that can be construed as creating a contract of employment, saying, once you're here, you're here for life and you're locked in kind of thing. Sometimes you see that it's like, we want an employee to be for life. So you got to kind of balance, like, we want you to be here and be successful for long term versus something that can be construed as a promise. So that's why it's important to have the things like the handbook disclaimers and the things in the offer letter, so that can't be used against you. So if you have that in a cultural statement within a handbook, but you got the disclaimer up front, then you're okay, right? But it's still, you still want to be mindful of making promises anywhere, even with a disclaimer. So you're kind of free to, I think, put what you want in there, but just be mindful of things about creating promises of future payments or any kind of promises of employment beyond what you're
would this be a place to include a DEI statement, or no? Would that be separate?
You could, I mean, again, that's kind of up to you, but I mean, I think it would be acceptable to include it there.
Okay, thanks.
So what about, like, with much of the, I don't know how to term it other than political correctness, and, maybe wanting your employees to operate on a certain code of conduct or something along those lines?
Yeah, those are all acceptable things. If you want to have, you see lots of employers that include, like, code of conduct or code of ethics within an employee handbook, or even as a separate policy, just to say, we expect our employees to behave X, Y, and Z. Those types of things are appropriate to include in handbooks and policy manuals.
Okay. So Brooks, also, what about now that we have employees working across state lines? Do you need to put something in there that the employees are bound by this, laws of the state where the company is and not their own personal?
Correct. You're going to want to have addendums for wherever they're working. It does get tough now when they're across state lines because, typically it's where you report to work is the laws you're under. But now if they're going to be a full-time remote somewhere else, you'd want to, they're going to be subject to the state laws of where they work, which so it would be important to include any kind of addendums in it, say a handbook that are specific to another state beyond South Carolina.
Okay, so if I understand this correctly, if the company's in South Carolina and the employee is in Tennessee, you need to know what the Tennessee laws are, or maybe it's not an at-will state.
Correct. You're going to want to know the Tennessee laws because they'd be subject to those. So, I mean, like, for example, if they were to file unemployment, it would be where they're working. They wouldn't file for unemployment in South Carolina because they're working in Tennessee. So they would be, the laws of Tennessee would apply to that employee.
Ooh,
Yeah, so what we
ahead.
see is a lot of companies that do work in a lot of different states will have a main handbook, so to speak, that just has all the general policies, and then they'll have separate addendums, like Brooks said. And if there's any separate disclaimer language that you need in those specific states, that will be included in that state-specific addendum where that employee will sign that specific addendum in addition to the general manual.
I had a question regarding the whole contractor employee thing, particularly with a lot of startups that we have that will hire developers. And two classes that I think are fairly common are developers and we call them customer care, customer service people, both of which have fairly loose job descriptions, right? It's not like an assembly line or anything like that. And it's very convenient, as you can appreciate, to have them be contractors then. And it is generally fine with the individual. In other words, that we sign an agreement with them. The part that gets messy is we'll oftentimes provide them with equipment or some equipment, not necessarily all equipment. We will, for instance, in the case of a customer care person, we might say it's your job to man the phones during a certain period of time, but they oftentimes will field calls outside of that period of time and so forth. Do you have any thoughts on how some general things to make sure that you're on the right side of that so that you're not challenged?
Yeah, I mean, it's a tough question because you obviously want to get the work done, and if you want to classify somebody as an independent contractor, there's certain things to look at. One question I have for you is, do these contractors, let's call them contractors, do they work exclusively for these companies, or is it where they can work also somewhere else potentially?
Great question. And I'd say it varies. I'd say probably, if I go through my experience, maybe half of them have some outside other work, but others, they just choose. In other words, we've given them enough work that they don't seek additional work. And that can change.
And so I'd say, yeah, that's one consideration in that scenario. And again, I'm not completely familiar with what they are doing, but it seems to me like that is more of an independent contractor relationship, particularly if they have the freedom, even if they are working exclusively for that company, if they have the freedom to work elsewhere and do specific jobs, projects for other companies, and they're not tied specifically to the companies that you're referring to, then that, to me, that tends to weigh more towards the independent contractor, knowing what you just told me.
All right. And it sounds like putting that clause in the contractor agreement would help strengthen that. Is that?
Yes. Yeah.
I mean,
So the lesson about the agreements is simply having the agreement is not dispositive. That's not going to be your golden ticket to assure that they're an independent contractor, but it does help. and it does help to show that that relationship is what you want it to be.
Yeah. And I mean, we've also had them submit invoices regularly. We pay them on invoices. The invoices can vary. I guess my question is, since this area is so murky, is there some set of things one could do that would, I know there's no guarantees, but kind of some guidelines that say, if you have a contract, if the contract also states they can work for other people, if the invoices are paid through that system and the invoices change in value, for instance, is that a sufficient set of rules to
Yeah.
You see what I'm saying?
Everything you just told me are some practical steps to take. Yeah, I mean, exactly. Paying by invoice, paying by job, that's an independent contractor type payment, right? You're not paying them a set amount weekly, for example. So all those things that you just told me, if I were looking at it objectively, if I was the decision maker, I would say that they are independent contractors.
Okay, thanks.
Along those lines, Michael referred to equipment. What about software? If you're having the independent contractor work on your, work within your software systems, such as your CRM system, or I don't know, let's say you're a CAD designer or something like that.
Well, I'll go one step further, Aaron, because that's a very practical issue. For instance, with developers, software developers, oftentimes the software they need to do the job can be very expensive. And particularly if our project requires a particular type of software, and it's much more cost effective for the employer to provide, I shouldn't use that word, for the company to provide that, that software for them, rather than having them purchase it independently. One, we can perhaps get a better price because of quantity and all that sort of thing. How does that play out? I guess that's a tag on to Aaron's question.
Exactly, and that's not, again, that's just one factor. And remember, control is the main factor, but equipment or using the software, I would put down on the lowest of the low for the factor requirement.
Okay.
So that's not going to be dispositive of the issue. Again, it's looking at the situation and arrangement holistically. And based on what you've told me, I feel very confident that those individuals will be independent contractors.
Okay, great.
Thank you. And thanks to all of you for staying on a little bit longer. If Michael, Ann, and Brooks, if y'all have a few more minutes, maybe Costas or Katrina or Tina or Claudia or Raj or Cindy, maybe y'all have some other questions?
Well, I had one that's somewhat off topic, but hopefully is quick. I noticed that Ann and Michael have a 4-character, looks like their last name and then a 4-digit. I don't know if that's a phone number or what, but maybe you could explain that, and more specifically why you do that, because I've seen that before, and I'm assuming that there's some legal reason for this.
Oh, no, it really is not. It's just, I guess that's our employee number at Ogletree. So we're using the Ogletree system. So yeah, it's not some secret code or anything like that.
I changed mine when I logged in, so I had it too.
All right, well, I have a quick question for Ann. All right, of course I forgot it now. With the I-9s, oh, where was it? Of course, now I've forgotten. But Brooks, all right, so I have a question for you.
It'll come back.
I'll come back to you. I'll come back to it, but it was with the onboarding.
Mm-hmm.
How are companies gonna get in trouble? And I remembered now, Ann. But how are they gonna get into trouble, other than the disclaimer on the front page?
Well, that would be, I guess, where you would get in trouble for that. The onboarding is more of kind of a global look at it for best ways to get people on board for being successful employment and not having high turnover. So I don't think you're going to get in trouble for the onboarding stuff. The legal issues would be offer letters where you put in language that creates a contract of employment, or not having a good disclaimer where you're opening yourself up to litigation in those regards. Just having a poor onboarding process could, like we said, just could lead to turnover and issues with the person's employment, but not necessarily legal trouble. That's why I brought up the offer letters and the disclaimers for the legal aspect of it. But the onboarding process overall is kind of just trying to help have a smooth transition for when somebody's coming to your company and making sure things go right. Because if that process isn't well done, then you could have turnover. They could be working and spinning the wheels in the wrong direction, wasting company time and resources. So it's kind of a holistic approach, and then know that there are some legal pitfalls along the way with the offer letter, disclaimers, and the Payment of Wages Act.
Okay. All right, good. Thank you very much. All right, so Anna, I remembered. I knew I would. So you were talking about the audits.
Mm-hmm.
Is there, for a small business, I mean, what's the likelihood of them being audited for their I-9s?
That's really hard to say.
Okay.
When this administration took office, they really ramped up the I-9 audits. Like literally they were just like mailing out subpoenas right and left. And so we had a bunch come up, even for small companies, like very like local small companies. We had a bunch come up, and then it's been 2-3 years since those companies were audited, and they still don't know the results, because the administration was really just looking for people who aren't authorized to work in the US. So they did all these audits, and they would do kind of a quick check, and then if people were authorized, they kind of put them on the back burner to look through to see if there were any sort of like paperwork violations, or at least that's my interpretation of what happened. Obviously they didn't come out and say that, but I know that I-9s, or that the audits or results are definitely still pending. So, whether that's going to be a priority for the future, the current or the incoming administration, who knows? But it is possible. There's so many companies, it's hard to say what your rate is. Certain industries are at higher risk. So staffing agencies, they like to audit those. Manufacturing can be, higher risk. You hear about raids kind of at manufacturing locations, or like food production. The hospitality industry as well. I'm trying to think what else. Those are kind of the construction, anything where, there's historical data related to them employing people who aren't authorized to work in the US. You tend to see more audits of those types of organizations.
Okay, thank you. Thank you. Any last questions?
Speaking of audits, I had a company with 10 employees get audited by the DOL recently for overtime issues. So again, these types of things can happen to businesses of all sizes. So we need to be prepared.
Very true. Okay, well, good. Well, thanks to all of you, Brooks, Ann, and Michael. And also, Cindy, thank you very much for your organizing, and Jared for our technology. Thank you also, Ogletree Deakins, for sponsoring our workshops this past year. We want to wish everybody happy holidays, and as much as we wish that things would be different on January 1st, we will just adapt and continue forward. And next year, we will be changing things a little bit with the way we operate with the Upstate Entrepreneur Ecosystem workshops and networking and educational forums. So we will just watch for more information about that. And thanks to all of you.
Thank you.
Take care.
Happy holidays.
All right, thanks. Thank you.